Hi everyone, my name is CS Harshdeep Singh Narula, and today in this video we are going to discuss about fast track your trademark opposition process. You must have received the opposition notice and you must have filed the counter statement as well, or if you have not filed it yet, or if you have already filed it like 1 year ago, 2 year ago, or 3 year ago, and you must be wondering that why your trademark process, why your trademark opposition process is not moving further forward in a faster pace. So I'll explain you how it works, the normal process, and how you can fast track it within few days and few months, because the normal waiting period is like 4 to 5 years, and why should we wait for our opposition cases for 4 to 5 years when we can build our brand throughout. So today I'll explain you the process and how to fast track it and which documents and which application goes in fast track process. So in the normal course of action under section 21 of the Trademarks Act, the opposition is filed. So I'll just explain you a little bit about these things, then we'll move further to the real part, and that is how to fast track your trademark opposition process. So under section 21 of the Trademarks Act, the opposition is filed. It is filed as per rule 42 read with rule 43 of the trademarks rules. Further, when we discuss about this, I'll explain you under which rules the trademark opposition carry forwards. So we have learned about section 21 and we have also learned about now rule 42 and rule 43. So under rule 42, the trademark opposition notice is being sent. Under rule 43, the rule 42 opposition notice has to be read with rule 43. In rule 43, the terms, the law, how to prepare the opposition notice has been explained. So this is notice of opposition. These are terms and conditions. So 44 is what? So when you got your trademark approved, accepted and advertised, after that there is a window of 4 months. During that window, any person can file opposition to your trademarks application under rule 42 within 4 months of advertisement and acceptance. So after notice of opposition you have received, you will file counter statement in rule 44 read with rule 43 within 2 months of receipt of notice of opposition. Further, the evidence will be filed by the opponent who filed the opposition notice in rule 42. The evidence will be filed within 2 months of receipt of counter statement. This is under rule 45. Then the one applicant who filed counter statement will file within 2 months the evidence. So rule 42 is notice of opposition, rule 44 is counter statement, rule 45 is evidence by the opponent, rule 46 is evidence by the applicant. So this is the major process which you have to follow. That means 4 months time will not count right now, because if you are watching this video, that means you have already received the notice of opposition. That means 4 months has already been crossed. Now what? 2 plus 2 plus 2. That means max 6 months. These are the mandatory 6 months that you have to give. Now moving further. Further rules are rule 47, rule 48, rule 49, rule 50 and rule 51. So these rules from 42, 43, 44, 45, 46 takes only 6 months period or less. However, the major game starts from here, rule 47. You must have seen, if you have already received the opposition for your case, you must have seen that for 4 to 5 years, there is no hearing in the case of opposition matters. No hearing for 4 to 5 years. So that means we can fast track this as per the law. So rule 47 means the evidence, the opponent has choice to file evidence within 1 month of receipt of evidence under rule 46. It's the choice. 48 means the officer, hearing officer, may call upon the evidence from both the parties, opponent and applicant. It's a choice. It's depend upon the hearing officer. 49 means translation of documents. For example, if you have the language other than Hindi or English, you understand Kannada, or you have or you understand Malayalam or Punjabi, then you need to get your documents translated. For that case, this is translation. Rule 50 is hearing, and rule 51 is cost. Cost means what? When there will be hearing, there might be any cost, like the officer may or may not award the cost. So I was explaining you this. Moving further, we'll explain about the fast track process. This process took what? This process took 6 months of your time. However, this process, which is not even required, killed your 4 to 5 months. Now we'll move that how to fast track the things here. So, what we were discussing, 42 done, 43 done, 44 done, 45 done, 46 done. So this will not count. These are just terms and conditions. 42 done, 44 done, 45 done, 46 done. Now under rule 34, you can file form TMM with fees of 20,000 if you are a small company or individual. Or if you're a large company, then 40,000 has to be paid. Then your fast track process will start. Now your application 47, 48, 49, 50, 51 will be completed within how much time? 3 months of filing of form TMM. This is what we call this. We call this expedition application. We call this fast track process. The government has provided you with this. However, they are charging you for that. But this is a very good step. It will save you 4 to 5 years. Expedite process. That means fast track application. This will only take your 3 months. That means 47, 48, 49, 50 all will be completed within fraction of days or weeks or months. That is couple of months. If you have any queries regarding this, if you want to get your trademarks process expedited fast track basis, then you can also contact us. We provide this service. Our contact is 987-806-7337. You can anytime WhatsApp me or drop a call. I'll be very happy to serve you. Thank you very much.